Welcome to the second part of our fall webinar series, all about guardianship, Guardianship 101. I am going to be talking tonight all about guardianship. It's an area that's near and dear to my heart. It often gets a very bad rep, but it's a very important area of law. And definitely does not get the positive attention that it should get because of all the good things and all the ways that it actually can help someone have a better quality of life. So tonight we're going to jump right in and talk about guardianship. But before we do, I just wanted to go over a couple of housekeeping things. We always record our webinars and we post them to our website, so you can find that information online on our resources page. You can also request a copy of our slides and we can send that to you by email. And I do mute all of the attendees, and if you have any questions you can save them till the end or put them in the chat box. And just a disclaimer that this information that we share during our webinars are for informational purposes only. They're not to be relied on as legal advice. And if you do have a guardianship matter or any elder law or estate planning matter that you want to talk about, you should definitely seek the advice and counsel of an attorney, and we are happy to help you with that. So what are we going to talk about tonight? We have three things that we'll be talking about. The first are what different types of guardianships, what is guardianship. We'll talk about the guardianship process, and then we'll also talk about some alternatives to guardianship. So guardianship is often the last resort. So let's jump right in and talk about what is a guardianship. Guardianship is a judicial process where a court appoints a person or an organization to make decisions for someone else who needs help making those decisions. And they could be decisions regarding personal matters, financial and healthcare matters, like deciding where someone lives, what kind of medical care someone gets. So there are, in a guardianship, you hear guardianship all the time, right? And the guardian is the person who makes decisions relating to healthcare and housing and who can visit that person. But there's also a second part of this, and that's often called a conservator. And that's someone who's making decisions related to money and asset management. So deciding what to do with that person's house when they can no longer live in it, and maybe they need assisted living or nursing home care. Do they sell that house and use those funds to pay for their care? Or also just paying bills, managing their bank account. So it really can run the gamut of what a conservator needs to handle for what we call is the incapacitated person, the person who needs the help making their own decisions. So why is guardianship such a big deal? Why does it get such a bad rep in the news and online in the media? And that's because oftentimes guardianship, first of all, guardianship strips you of your legal capacity. So the court is saying that you don't have the ability to make your own decisions anymore. Which is a big deal, because by doing that, it also is removing many of your constitutional rights. So you no longer have the ability to get up and make any choices that you want to for yourself. You need to get the permission and approval from your guardian. So that means that our fundamental rights related to getting married, voting, owning a gun, freely associating, all those go out the window. So our right to freely associate is when the government can't interfere with our personal relationships. Well, now the court is saying that someone else has the authority to decide who can and can't visit you, who you can marry, if you can vote. Can you drive? Often you're stripped of your driver's license. So guardianship is a very big deal, and it is something that should never be taken lightly. It is a last resort, and when you're going for a guardianship, it's important to always look at, is there a lesser restrictive alternative? Is there something else that could help this person that is not so restrictive, because there just might be. And we'll talk about what those alternatives are later on. So a lot of what's been going on in the media lately also is talking about all the ways in which guardianship can be abusive or predatory. And without the right guardian, there is a risk of abuse and exploitation. And that's exactly what this system is designed to protect against, but it's also very easy for a guardian to become abusive to their ward. So what happens sometimes is they could isolate that person. They could keep them away from friends and family. They can have excessive and unrestricted control. If there's no checks and balances, then they could be holding all the cards and be controlling this person. And they also can be financially draining, because this guardian could have access to all of their ward's assets. And yes, there are accountings that need to be done and filed with the court, but that doesn't necessarily stop someone who's going to commit wrongdoing or isn't the right person to be the guardian and manage assets. So one bad egg spoils the bunch, right? The reason why guardianship often gets such a bad rap is because of the things that we read in the newspaper and we see online in media. And there's a number, you can Google a number of celebrities that have gone through guardianships that just are messes. You can Google other just everyday people who have ended up in a guardianship unknowingly. So some of the big ones that you might have seen in the news, for Britney Spears has been all over the place recently. She's had a guardian conservator for the last 13 years after she had a mental breakdown. Her father's been controlling all of the aspects of her life, where she can go on vacation, what she can spend her money on, who she can hang out with. Her father actually just petitioned to end the guardianship recently. I don't think a judge made a decision on that, but it would be interesting to see where that goes. And of course, Britney has been very vocal recently about how her guardianship's been abusive. Amanda Bynes is another one. I don't know if anyone remembers her. She was on Nickelodeon. She was a child star. She had mental health issues. I think she was diagnosed with bipolar disorder, a number of substance abuse or misuse issues. She couldn't make her own decisions. And back in 2014, her mother became her conservator. She has been in a treatment facility and she wants out. She's been trying to get out, but her mother won't approve it, won't give her the okay to move out of there. And so she's stuck. And she's also been trying to end her conservatorship, but not necessarily saying that if the guardian or conservator isn't doing what the ward wants, that's necessarily a bad thing, because there's plenty of things that there's a difference between what's in our best interest and what we want. They don't always align. And I think Amanda Bynes wants to get married. So maybe it's that person that she wants to get married to isn't necessarily the best person for her. Then we had Brian Wilson. He actually was a member of the Beach Boys. He, again, had mental health issues, and his psychologist, actually the one who diagnosed him, was the one that used his influential relationship with him to start controlling his assets. His family was concerned that he was over-medicating him and would use that as a way to control him. And then finally, there was another family member that petitioned the court and became his conservator to protect him from exploitation. So that's actually a situation in which guardianship was able to be used to get rid of the person who's doing the exploiting. Casey Kasem is another major story that was in the news. If you didn't catch this one, you can go online to caseycares.org. I'm sorry, kasemcares.org and read all about it. This was actually a very interesting case. Casey, we all know he was a longtime disc jockey on TV. He had Parkinson's disease, and his wife had become his guardian and conservator. She had isolated him, prevented his children and his other family members from seeing him. As at one point, she took him out of the hospital. She took him away to another state. She hid him from everyone. And there was a huge court battle between the wife and his children from another marriage. And eventually the children prevailed and got him out of wherever she was keeping him, but then he died shortly after that. But ultimately they were able to bring him home and have those last moments with him. And then there was Mickey Rooney. So he was a well-known actor. Over his career, he was in 300 plus movies. He had been married a number of times, but his 8th wife and his son were abusive to him. And they stole money. They would withhold food and medication from him to help control him. And eventually, Mickey Rooney's attorney filed for guardianship and was awarded guardianship. And actually the judge granted a restraining order against his stepson to help keep him away. So guardianship, every 2 cases is never going to be the same. And a lot of what plays into it is family dynamics, as you can see. And it's oftentimes a fight over control. One family member wants to be the controlling person, or they're controlling everything and they're the bad actors. And someone else needs to step in if they're not doing what they're supposed to be doing. So what are the different types of guardianships? You can have a full guardianship, and that's when the guardian has full control and decision-making power. They can make decisions about all aspects of their ward's life. And then you can have a limited guardianship where it's narrowed down to certain legal powers and duties, like if you just need a conservator or you just need someone to make medical decisions. Maybe that person has capacity to make decisions on other aspects of their lives, but they can't manage their assets. That is also something that's very likely. You can also have a private guardian or a public guardian making decisions for you. So a private guardianship is when the court appoints a private person, usually a family member, a friend, someone who knows the ward well, knows the type, what's in this person's best interest, what's the level of care that they would need. So that would be considered a private guardian. And then you have a public guardian, which could be a nonprofit or a public organization, or some places have volunteer guardian programs where attorneys or maybe professional guardian steps up to fill a need in the community where guardians are needed. So I practice in Virginia and New York. So some of the organizations that we have in the jurisdictions that I practice in is the Arc of Northern Virginia. They handle guardianships for people with developmental or intellectual disabilities. There's also Bridges Senior Care Solutions. And then in New York, another organization that does guardianships is Family Service Society of Yonkers. So these are some nonprofits or public organizations out there that will step up to be someone's guardian if needed. And this actually happens more than you would think about. There's also often a lot of seniors out there that they don't have any living family members or trusted loved ones or friends that could step up and make their decisions. So there is a huge need for organizations like these ones to step in and fill in the gap. So what's this guardianship process look like? How complicated is it? What do we have to go through if we're interested in becoming a guardian? And that definitely depends on the state laws from state to state. I will say that, again, I practice in Virginia, practice in New York. The process is very different between the two. But there are some things that are similar, and we'll touch on that. So how does a guardianship even happen? How do you even need a guardian? So there's a few ways it happens. So a lot of times what happens is when you have children that have intellectual disabilities or developmental disabilities, as they age and become adults, they still need someone to make their decisions. They don't just turn 18 and can magically handle all their decision making. So this often happens when the parents petition the court to request that they can continue being the guardians and the decision makers. So they will usually 6 months out before the child's 18th birthday, they will petition the court to ask to allow to be the guardian. So that's one way this happens. Or we have someone who's an incapacitated adult. So that would be an adult who lacks the capacity to make their own decisions. Maybe they have a developmental disability, an intellectual disability. Maybe they have an illness that makes them unable to make their own decisions, or even just is so, has a number of physical symptoms that make them unable to act on their own behalf. Maybe they have Alzheimer's or dementia, Parkinson's. There's a number of things that could happen. Maybe they have mental health challenges. Maybe they have a diagnosis of schizophrenia. I mean, it really could be anything that can incapacitate someone and make them unable to make their own decisions and understand and appreciate the risks and the risks and the effects of the decisions that they do make and how that would affect them. Another way people need guardianships and how this often comes about is they don't have any estate planning done, or even the improper estate plan. So if they never signed a power of attorney, never signed a healthcare proxy or a medical directive, or I've had cases in the past where they had the documents, but they weren't properly executed, or the documents didn't give their agent the powers that they needed for certain transactions. So they didn't have the right estate plan, or they were missing one entirely. So a guardian was needed, a conservator was needed, a court needed to appoint someone to allow them to make those decisions. And another thing that pops up, it's a huge problem that's really on the rise, is exploitation and abuse by a stranger, by a family member, someone who is intertwined with scammers, giving all their money to them. But you'd be surprised how many people are exploited and abused one way or another by a stranger that just took a liking and paid attention to them and befriended them, or another family member. So if you have someone that's in need of a guardianship, the process generally is that a petition would be filed, and the person filing the petition is called the petitioner, and the person who is in need of the guardian is usually called the alleged incapacitated person, or the respondent to the petition. And in this petition, the state statute will lay out certain facts that needs to be in there, and you would nominate someone who would be the guardian or conservator. Notice is very big in this process. It's giving notice not only to the person who's the subject of the guardianship, but the state statute often will lay out who's entitled to notice. So maybe somebody that they live with, family members. There are parties that are entitled to notice in these proceedings. Oftentimes in Virginia, this always happens, and in New York, sometimes it happens, but the court will appoint another attorney, and they're either called a guardian ad litem or a court evaluator, and that is another attorney that is going to investigate the petition. And in a nutshell, that attorney will look to whether this person does have capacity, right? Are they able to make their own decisions? Do they really need a guardian? And is the person being nominated appropriate to be the guardian? Are they going to have their best interests in mind? What is their long-term plan of care for the person? How are they going to meet their needs or help them make sure their needs are met? So the guardian ad litem or the court evaluator will do their investigation and make recommendations as to really what needs to be done. And sometimes also the alleged incapacitated person, it's recommended that they have counsel as well. They might object to this, or we might need to make sure that their interests are being represented. So they might need an attorney appointed to them. But that's something that the guardian ad litem can recommend in their report. And then there's a hearing. And this is when, if this action is contested, This is when both sides show evidence, they put forward evidence. Maybe it's a medical evaluation, medical reports, testimony from family, friends, witnesses, doctors. It really can run the gamut depending on what's going on in this case. But guardianships definitely are definitely contested. And then once the judge reaches a decision, a final order would be entered. It would outline the findings that the person is incapacitated, the powers and the duties that the guardian has, whether it's a full guardianship, a limited guardianship. It would all be outlined in the order, because that is going to be signed and entered, and that's what the guardian is going to be operating from. And then it will also list all those rights that the alleged incapacitated person loses, and you know, normally they're losing the right to vote, own a gun, have a driver's license. All those things get removed, and sometimes you can preserve them, but a lot of times they end up losing them. And then after the order is entered, then the guardian needs to be qualified. So they would get certificates of guardianship. That's the actual stamped and sealed papers that they would present showing that they are the guardian. They would take an oath with the clerk of the court. And a lot of times if there's assets involved, they have to give a bond, which is like an insurance policy in the event that they run off into the sunset with the ward's assets. But that's not it. We don't just get the order, qualify, and then call it a day. There is some reporting that needs to be done, typically on an annual basis. So they look like annual countings that's due to the court or the commissioner of accounts, and then a yearly report of the guardian. And that's just really a document where you are telling the court the state of the affairs. You know, where does the ward live? How, you know, do they see the doctor? What are their diagnoses? All those nitty-gritty details that you need to report back to the court to let them know what's going on. Now, in the beginning, I mentioned that there are some alternatives to guardianship. Again, this is a process that I would say is a last resort, that you don't just jump up and say, I want to go get a guardianship necessarily, that you want to explore whether there are other alternatives that are not as restrictive. So how do we do that? What are the alternatives that are available to help us prevent needing a guardianship? So the first one, and I think the easiest and the most common, is having a power of attorney and an advance medical directive. And that is going to cover the basis of who's making your financial power of attorney and medical decisions. That's your medical directive. But the key to this is also making sure that it's properly drafted to deal with your incapacity, and it is properly executed. So when someone signs these documents, they have to have capacity at the time they're signing it, meaning that they have to understand the document, know its effects of what they're signing. So this means that if you had a stroke and you were unable to speak and understand how to count, and you didn't know what day it was, and you weren't oriented, that's not the time to go and sign a power of attorney. This is something that you do in advance, that you're pre-planning, and in the event that there comes a time when you're incapacitated. So we do this when we are well and healthy. And these documents have to be signed and notarized and witnessed. So that means that they have to be properly executed. So if they're not properly executed, then they may not be accepted by the people that you need to work with to get the decisions made on someone else's behalf. And then oftentimes that's when you're stuck going for a guardianship. Another alternative is having a representative payee. This is someone who is appointed through Social Security to manage only Social Security benefits on behalf of someone else. So sometimes depending on someone's situation, all they need is a representative payee. So this is a great way to make sure that those benefits are managed without going through the time and expense of a guardianship proceeding. Trust planning, another great tool. If someone has assets, then they can put them in a trust, appoint a trustee to manage them, protect the assets for them in the event of their incapacity. So that's another huge, awesome tool that we use all the time to plan for someone's incapacity. And the last one is supported decision making. So this supported decision-making is gaining a lot of popularity across the country. It's for people with intellectual or developmental disabilities. I have not used this in my practice at all, but again, it's gaining a lot of traction across the country. It's the process by which someone with an intellectual or developmental disability can appoint a decision maker, or someone that can help them make decisions relating to financial decisions, healthcare, or just life situations in general. So it's not as restricted as a guardian and conservator. There is an agreement that would be signed by the parties, and it's basically there to empower the person to make decisions, to make their own choices with the support of other people that they trust. I think that there are some definite pros and cons to this model. But it is an alternative to a guardianship nonetheless. And if you are interested in learning more about it, like I said, it's gaining a lot of popularity across the country. Google this and you will find a ton of resources on it. So what now? What do we do? Now that you know what a guardianship is and how it works, it's important to know that guardianship can be avoided, and it's really simple. You can make sure you have an estate plan that plans for your incapacity, because none of us have a crystal ball, but I can promise you that there is going to come a day when you are not able to speak up and advocate for yourself, and you need to make sure that your wishes are known. And you need to make sure that you have people that you trust in place to make those wishes come true. So planning is a huge piece of this. Guardianship can be avoided with the proper planning. And if you're interested in talking more about this, let's chat. Let's schedule a consult. We do not charge for our initial consults. We can talk more about estate planning and how you can plan for your own incapacity. Or if you have someone that needs a guardianship, we can talk about, maybe an alternative or a possible guardianship proceeding. So if you want to find us, there's plenty of ways to do it. You can find us on social media. We are on LinkedIn. We are on Facebook. You can email us at info@monteleonelaw.com. Give us a call or visit us online. Thanks so much for tuning in, and we look forward to hearing from you.